Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you. You've joined the Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. I am your host, Saul Gruber from Gruber Trial Consulting. And today we're going to talk to Sean Domnick, a top lawyer out of Palm Beach County, Florida, who's also the incoming vice president of AAJ. Sean's going to give us some tips about how he's learned both good and bad in trying cases for the last 30 years with some, of course, as always, entertaining war stories. Sean's also going to talk to us a little bit about some of the stroke cases he's been handling and how he can help you with your case if you need. I think this is going to be a really good podcast. You're going to really enjoy some of the tidbits Sean gives us. So let's take a listen, shall we? So thank you. This is The Jury Thinks What, a podcast about trial lawyers by trial lawyers. And this is Saul Gruber, your host from Gruber Trial Consulting. And we're here with an old friend of mine, Sean Domnick from Palm Beach, Florida. Sean is an incredible trial lawyer with incredible verdicts. But just as important, I think, he's the incoming vice president of the American Association for Justice. So Sean isn't just fighting for his clients, everyone. He's fighting for every trial lawyer out there. Thanks, Sean, for coming on.
Thanks for inviting me, Saul. Happy to be here today.
So I know I've been to your office, and I've been lucky enough to sit down with you and your partners and some of your associates just to talk about the concept of trying cases. And I know how important it is to you. Why don't you tell our audience how you got involved in actually becoming a trial lawyer?
You know, it's interesting. From the time I was a young kid, all I ever wanted to do was be a lawyer. That was my goal from as far back as I can possibly remember. And, I got lucky. Sometimes, you know a general thing of what you want to do, but the specifics of it. And when I was in law school, I ended up clerking for the Searcy Denny firm. And
I didn't realize that.
And that summer, Chris Searcy was in trial for the summer in a case, I think the case was called Salinero, a tragic case. And I got to sit down in the courtroom and watch Chris in trial during that summer. And so I said, this is for me. This is what I want to do.
I think there's something about watching and talking to a real life trial lawyer that and the way they think that it's unlike anybody else you talk to.
It can be exasperating talking to a trial lawyer. It can be engaging. The analytical mind about how it is that you go about looking at things and try to deconstruct it is really incredible. And the other side of it is we're always trained to look for problems. And so that's all we do is we look for problems. And sometimes that bleeds over into our personal lives in a way that's not really good for us. But
boy, that's an understatement.
Yeah, absolutely. So you have to make sure you create that balance and know how to turn things off with it. But when you talk to people who are great trial lawyers, and they have all sorts of different personalities, people who are funny, people who are stoic, and everywhere in between. But it is about the preparation that they put into the case. It is about how much they care about their clients. Those are things that are become common threads that are there. Those are the lawyers that go and meet with their clients at their houses, not just talk to them on the phone, that go to the scene of the accident or go stand in the operating room where the malpractice occurred, and you just close your eyes and you look around and you breathe in what it is that's happening. And when you do that, there always comes a point in the trial of the case where a witness will say something and you'll be able to say, wait a minute, that's not true because I was there and I know this to be it. And the jury then knows that you have done your homework and that you are now a trustworthy guide to take them to where it is that they need to go. So those are sort of the common threads you see.
And that's incredible because, I mean, we've been doing this podcast for just under a year now, right? And the whole goal, and I've talked to you about this, the whole goal was we wanted to put something out there that wasn't just lawyers speaking from a podium and not just lawyers writing a book.
Right.
Right. We wanted it where we can have a conversation because all these things go through every lawyer's mind. What you just said is something that every single attorney I've had on this show has said, from Brian Chase to John Gomez to Bob Jennis, Jay Vaughn, every one of us, every one of you, I should say, has said the same thing. Unless you're out there going to the scene, spending even a day or a night with your client or their family at their house, you're not going to find what the true story is.
Oh, that's so true. And you think about it, like, think about a catastrophic injury or a death case. And you'll say to your client, well, send me these pictures or send me whatever videos you have. Then you learn and you start to realize that there are things that they cannot face that are in their house. There are pictures and stuff that they just can't do. So they're only going to send you the tip of the iceberg.
Right.
And if you don't go to the house and say, what's that picture on the wall? Why is that hanging there? Why is that? Tell me about that time period that's there. And then, you know, in trial, particularly in wrongful death cases, jurors, you know, they want to connect. You have to show them what was there in order for them to measure what was lost. So what I'll do with my clients is get them to get the most important pictures or mementos of their life. And I have them stand up in front of the jury and I have them talk about the good times.
Right.
What tell us what you were doing here? What does this tell us about whomever it is that was died? How did this do? And you just, their faces, one is they're not sitting up there on this witness stand just crying their eyes out with no matter how true it is. We know that jurors just don't connect with somebody who just gets up there and says, tell me your name. And for the next 45 minutes, all they do is cry. And so it takes them into a place that is where they are actually animated and engaged in all of that because they're telling the story of the life. And so I have found that to be very effective. But you don't have that if you haven't gone out there and developed the story. And you know, I think most trial lawyers love the movie My Cousin Vinny, and we laugh about the courtroom scenes. But remember, none of those courtroom scenes would have been available about the bushes and the crud on the screen and how long does it take to cook grits and magic grits if Joe Pesci had not gone, if Vinny had not gone to that guy's house while he was cooking breakfast, if he hadn't gone out and met with Mrs. Riley, and if he hadn't gone to the other house and seen how dirty it was all the product of the hard work that he had actually done before trial that allowed him to seem spontaneous at trial.
It's crazy because obviously the movie was fantastic, but one thing that hit all of us was how realistic it really was. I mean, you're not going to get all these admissions and find the real killer normally, but you're right. Those cross-examinations never occur if the Joe Pesci character doesn't go out to the scene and take a look at everything.
Right, 100%. And that to me is the biggest lesson to take away from that movie as a trial lawyer is that it is the groundwork that he did in preparation. And of course, he wasn't doing the groundwork on the legal side of it. And that was part of the comedy of it. And it wasn't until he did the groundwork on that side that everything came together for him. So, you know, so every case that you have, you've got that factual side of it. And then you also have, and I think you'll hear from most trial lawyers, where is it that we start with the case?
Right.
When our client is in our office talking to us, or we're out meeting with them for the first time, what is it that most of us are thinking of? What are we going to argue to the jury at the end of the case? What is our closing argument going to be? And then we kind of work backwards from that because we're developing the essence of what the case is really about. And, you know, you also have to have, what are the jury instructions going to be? What's the pathway that I have to get? What's the law? And I've seen lawyers that never looked at what the law is And so how do you take a deposition if you don't know where you need to go? How do you ask the question that mirrors the jury instruction if you don't know what the jury instruction is going to be in a case? So it's a lot of hard work.
Yeah, it's one thing we do in the consulting practice, and I did for, I don't know, 30, I'm getting so old. I think I'm even a year older than you, except I don't have the gray hair you have. But one of the things I say, the first thing we always did was pull the jury charges.
Right.
Take a look at the jury charges and see what they say. And in the nursing home world, I would take a look at the state and federal regulations for those issues and just go through them.
Right, and that becomes the roadmap to the case. And
sure does.
I'll give you a perfect example where really understanding the law is so important. It comes with causation. Talk about nursing home cases. Every one of our nursing home residents has a ton of comorbidities. They're old, they've got diabetes, they've got heart problems, all of these things that are there. And then this other thing happens and they die. And what's the defense? They're old and had all these other problems. So it's this.
Like clockwork, that's the defense. You can
right. We know it.
Anything on that defense.
And so we turn that into our strength of our case about how that means you need to care for them even better because you know how fragile they are. But when it comes to the causation component, virtually every state that I've handled cases in has what's called a concurrent cause instruction. And that is that the law recognizes that you can have comorbidities, but something can come along and be a significant contributing cause. It doesn't have to be the sole cause. It can be a significant contributing cause. So if you know that, when you're talking to treating physicians and preparing them, you can put them at ease about, let me show you what the law is here. This is it. It's okay for them to be old and have diabetes and all of those things. But for this other thing coming along, they would not have died at that moment. Causation, we've got our significant contributing cause. But if you don't know that as a lawyer and you don't have that, you're going to miss opportunities.
Yeah. If you don't know that as a lawyer, I think you have some problems in handling that case. We used to have the substantial factor.
Right.
And same thing, which is it wasn't the sole cause, it was a substantial factor in bringing along the resident's death. And I think if you're handling cases like that, you really need to take a look at all the jury charges for that reason.
Yeah, one of the difficulties today, and it's why we're so fortunate that we have AHA education that's out there helping young lawyers, is the way it's set up nowadays. So many lawyers, as young lawyers, aren't as fortunate as we were to have mentors to bring us along and show us stuff. And so sometimes you don't know what it is that you don't know about things. And so I'm not critical of them for not having these things because they've never been in a position where somebody has guided them the way that you and I were so fortunate to be guided. You know, we like to think 30 years in, oh, I've always been this way. And, you know, no, that's not the way that it works for us. And so I think that we have to have the same compassion and empathy for young lawyers today that are struggling that we have for our clients.
And that's one of the reasons we're doing this podcast, is for that reason. Is I had phenomenal mentors. I mean, and I was lucky enough that the first place I worked, my mentor were two people, David Kauser and Joe Collins. And they said to me, okay, here are our 10 worst cases in the office. We'll guide you as to how to try this case, but that's all we want you to do is try the cases.
Right.
They're horrible cases. We have them. Every lawyer has them. Rather than take $1,000, the clients would rather you try the case anyway.
Yeah.
And you like a bull in a china shop. There I am in 1989 picking juries thinking, I don't even know what this means. And then they would work with me. And then after 3 years, I had 15 trials under my belt. And it was only then that I could start to figure out what really made sense.
Yeah. Well, like you, as a young lawyer, I got to try a lot of cases. I tried, I think, like 23 cases in my first 15 months or so.
Oh my God.
I just was in a situation, I was in a defense firm, and the way we were set up, one of the lawyers who was like the senior associate in my pod went to another firm. So her case list, a lot of it fell to me. And so I got the opportunity to just start trying cases, which was just fabulous. But like you say, there's a lot where I'm like, why am I doing this? And I found that particularly true with picking a jury. right? They gave me, here are a bunch of questions that you can ask, and I'm asking them, but why do I care where somebody's address is? What is that? Why is that at all meaningful to me? And it was actually not until I was at a thing where Jerry Spence was, and when I flipped over and I was talking to him about my thought, because Lord knows no law school that I know of really prepares people to pick juries and really talks about it. There may be one or two out there that are focused on trial like Stetson, but most of them, they just throw you to the wolves out there. And I was saying, and he said, talk to them about what scares you about your case. And
isn't it crazy that there are lawyers out there that I mean, it's not demeaning them in any way, but where they're afraid to talk about the problems in their case in voir dire, that they're afraid they may lose the case.
Well, if you're not talking to them about the bad stuff up front, I guarantee you they're going to be talking about it back in the jury room. And don't you want to know who it is that's going to say what now? And learning to be open and honest and raw with the jury, and just letting go and really talking to them about your case, your client, your fears, all of that level of honesty, it takes time. And when they turn on you because now you're revealing things to them and you want them to turn on you because you want to find out who is just already a hater for you.
Right.
And to stand up there and to be able to take it and just say thank you, and who else feels how Mrs. Smith does?
Right.
Who the rest of you, that takes a little while to get used to. And I was just in Arkansas talking about jury selection at their convention. And, I asked, how many of you all pre-pandemic tried 2 or 3 cases a year? There were maybe 4 hands out of 100 plus people that raised their hand. So people are not trying as many cases for a variety of reasons. And so I was saying, that means that you have to come up with other ways to practice, because you can't just roll out of bed. You're not Allen Iverson, right?
No.
Not just you can't just roll out of bed and do this stuff. You have.
Well, you can, but you're not going to do it well.
You're not going to do it well. You're not going to do yourself proud, and you're certainly not going to do justice to the faith that the client has placed in you with that. So we talked a lot about that thing of what are the mechanisms that we can set up to practice these different things, these skill sets.
One of the things, it's interesting too. I mean, I became such a better trial lawyer once I got really deep into therapy. It was incredible. Right. The more I could open up and talk to my therapist, and by the way, every lawyer should be in therapy at least once a month. But the more I opened up, the much better a trial lawyer I was. I was actually able to look a little bit more inside me and get over the competition of I must win and get into why is this important?
Right.
And why does it really matter? And the thing we're doing now with a lot of our clients is we're just setting up videotapes. We're videoing them doing everything.
Yeah.
And it's not a matter of, oh, why did you do this? Why did you do that? But it's a matter of looking at yourself and actually really seeing what you're doing as opposed to what you think you're doing.
Right. And people don't like hearing their own voice. They don't like seeing themselves, the little tics that we all develop and the uhs or whatever it might be that you have. And so that's great. And I tell people, like, you really want to get raw with this stuff? Strip down and go in your bathroom and practice your opening in front of a mirror.
Yeah.
If you can do that at your most vulnerable, then you can stand in front of 6 people.
No doubt.
And do it. And
we have trials. We have a bunch of stuff going on all over the country, and that's we've done the focus groups, and now we're just tweaking different things. And rather than bringing me out there, I've said to everybody, and it's working pretty well, just go videotape it on your iPhone. Right. It doesn't have to be anything fancy. No. I don't need great lights. Just set up your iPhone and just do your opening, and let's look at it.
And a lot of people, they'll have this in their head. This is what I want to say. But if you never actually practice saying it, we know that in real life, the distance from here to the mouth is very, very long. And there are things that sound so great in our head, but then when they come out, they don't sound out loud the way they sound in
No.
our head. And you need to know that in advance. Trial's not the time to be guessing with that. But the sort of the corollary of that, at least for me, and I talked to others, and I think they went through the same process, is you spend the first 5, 6, 7 years of your trial lawyer life trying to be everybody but yourself.
Right.
I'm copying what I read in a book, or I read somebody else's direct examination or opening statement or closing, and I'm going to memorize it and I'm going to do them. And juries can tell when you're not being genuine and you're not being authentic with it. And that doesn't mean don't study what other people have done. Absolutely study it, learn from it, but then adapt it into you and who you are.
It's so funny that you say that. I was in the Keenan nursing home reptile group when the reptile first came out, when he first wrote the book. It was me and a few other lawyers you knew them all. And Dave Hoey, who's still his dean of whatever Dave is, we did that together. We started that together. And the one thing that always didn't sit well with me, not that that means anything, is that Don would say, you have to do it this way. Don't do it any other way. This is the way you have to do it. And I used to say, well, I don't know that really fits my personality. I mean, I have you know me, Sean, I have a certain way about me. Right. And if you're going to tell me that I have to be very stoic, it's just not going to work. Yeah, it's not going to work at all.
It's not genuine. So, I think what Ball and Keenan have done is phenomenal. Anybody that's giving up their time and energy to try and make people better lawyers, my hat is off to them, and they've given back so much of it. And I think that the structure that they give, particularly for lawyers that don't get to try a lot of cases, that there is a comfort to be able to say, okay, I've got a structure that I can work within. I think as you try more cases, that you develop your own comfort, and then that structure becomes can be a little bit, confining. And again, you have to adapt it to fit you. And we were talking earlier about you sort of have these extremes of the Jerry Spence and the David Ball Keenan approach to it. And we talked about the fact that I think that they both have so much that's good for them, but that there is a melding of the concepts that works. And you and I talked about Hollywood and how Hollywood, they take these movies and in 2.5 hours, they take us on an emotional roller coaster. They develop characters that we care about and that we remember forever. And they have lines that we remember forever. Right. And they do that in this short period of time. And what is it that we can learn from that in our cases, in the presentation of our cases, particularly in this day and age where, one, we're presenting more and more things by video. Mm-hmm. So those techniques now are more available to us. And you have jurors that, they're happy to sit on your case, but they don't want you to waste their time. So
at all.
And the judges are pressing us, be done with it, be done with it, be done with it. So how can we, what are those lessons that we can learn from that we can then take into our case that allows us to connect emotionally, but do it in a way that is concisely. And so I look at those things.
So let's talk about that, because we've all been saying that, right? I'm working my what off doing that with people. But how do you do that? How do you take that 1.5 week med mal trial that if you try, if the plaintiff puts on their case for 7 days, you're in a lot of trouble, right? That's just a long time. So how do you take the evidence of 7-day trial and make it into 2.5? What do you do?
So I think that what we really have to do, it's like, have you ever written a brief and you write the brief and then you put it away and you come back and then you look at it, and now these edits become self-evident to you with the passage of time. And I think our presentation of trial is the same. You start with, this is what I want to do. And then it's, okay, can I do it here, more narrowly? Can I do it more narrowly? And what I do in trial often is I'm always saying to myself, how can I jettison this witness? Do I really need this witness? This testimony came in great from this witness, Why do I need to have somebody else to come in to say the exact same thing and risk them not holding up under cross-examination?
Exactly.
And now I've lost the power of that. So it's thinking about it. It is really, what is my best way of making this point? How am I going to do it? And sometimes you've got to be repetitive. And I know judges always say
exactly
to us,
what I was about to say to you, but doesn't repetition
it does
burn it into their brain?
It does. It absolutely. So you have these competing tensions there, right? Everything is kind of like it's a tug of war, and you got to keep that tied around handkerchief between the two cones of constant repetition and overdone versus not really saying it enough or in enough different ways that you're connecting with the different ways that different jurors learn and assimilate information, because we know that as well. So those are the tensions that we're trying to compete with in our cases. But there are, and so then too, it's a matter of bringing structure to what it is that you're doing. A witness that if I'm putting an expert witness on, I've seen people put expert witnesses on and they don't get to their opinion until the last question that they ask them after 4 hours of direct examination. And to me, it's like, who gives a damn by that point? So it's, who are you? Why are you here? Did you formulate an opinion? Yes, what is that? Okay, now let's talk about how you did that and why it's a good opinion. So the jury knows why this person is here. And then I'll say, then you can incorporate, because I've got the opinion. In formulating your opinion that Dr. Jones was negligent, did you do this? And so now that's where my repetition comes in.
Got it.
For that. So but it is hard to really streamline, and you're trying to figure out, who do I really need to put on this case? And each case stands on its own. You can't say I did this in this case and therefore it fits in this case. I tried a case a few years ago, a car wreck case, where a guy came out from a side street in his Hummer, ran over our guy on his motorcycle. My first two witnesses one was 5 minutes and the other was 8 minutes long, and they were eyewitnesses. After them, the liability picture was done.
Right.
I could have sat there for 3 hours with each one of those witnesses. Why?
Right. You know what we do, and it's always helped me, especially in the past when I was actively picking the jurors. We would have just the names of the potential witnesses, and I would put, just on a legal pad, nothing fancy, what are the points I want to get from each of them?
Right.
And then if I see the same point on 4 witnesses, I start to think to myself, well, do I even need that 4th witness?
Exactly.
Get rid of them, or do I need the point?
Right.
Maybe we could still have the witness in for other things he or she is going to say, but avoid that issue just to make things go quicker.
Yeah. And so it's like, we're as strong as the weakest point. And so are there points that we need to bring to the jury that allow the other side to set up straw men, that if we are wrong on that one, then we're wrong on our main point?
Right. And
so what is the strength of my case? What is it that I really, really care about? What is it that really happened? Let's focus. Let's keep that as our focus of what the case is. And I don't care about all this other stuff. I don't need it. And of course, it's learning not to get into it. If you're battling with the defense expert up there, if you feel that floundering around, I mean, anybody who's tried cases, you feel that moment when you're like, and you just sort of turn to the jury, I think I ought to sit down. you just, because you're just in this floundering thing. So
it's a horrible feeling, because you're standing at that point in the middle of the courtroom.
Right.
Everybody's looking at you, and you just have nothing.
Right. And that comes from the where you're now fighting with the witness, instead of knowing, where is it that I can get things out of this witness, one that might be that we can agree on with us. And sometimes it's just a matter of, if they're not going to answer a direct question directly, you don't need to sit there and battle for 20 minutes. Jury gets it, and you just have to be able to deal with that in your closing.
Yeah, that's funny that you say that, because I watched a lawyer in New Jersey try a case right after I had lost a trial in Newark against the same nursing home. And or at least the same nursing home ownership and defense lawyer. And their trial was in Jersey City. I was in Newark. So if you're from New Jersey, you know where all that is. And what I watched him do was ask the question. The witness gave an answer that had nothing to do with the question. He said maybe the first two times something like, I appreciate that, but if we could just look at my question for a minute. And then after that, he didn't say it again. It was so obvious that this witness was never going to answer any of the questions that he made a point for the next 15 questions just to like say what was true, have the witness say whatever. And it got to the point where the jurors were rolling their eyes.
Right.
I lost. He got a $14 million verdict. So you tell me which was the better way.
Well, there are a lot of factors, of course, that go into those types of things. But some witnesses are really good witnesses, and they're tough to go after, and they're professional at it, and they've been doing it a long time, and there's a reason that they're there. And so the question becomes, am I getting down into the mud with these people? Is that really what this jury wants to see? And so, but there are things you can do. What is it that every defense expert does these days? None of them keep track of their money, right? They don't do it or anything like that. And they're making millions of dollars of it. And so I just say to them, I'm like, your job is to tell the truth, the whole truth, and nothing but the truth. You agree with that, right? You've been asked this question hundreds of times. You know that this is something that we care about. And if you wanted to bring the whole truth and nothing but the truth to the jury, you could do it. You just choose not to do it. Yeah. Okay. Why is he hiding something that, who cares that they get paid? It's not that they get paid that any of us care about. It's the fact that they can't even be honest about that.
Right.
And what does that mean about how honest they can be about anything of substance if they're fighting over that? Right? Our experts get paid $1,000 an hour. Their experts get paid $1,000 an hour. Own it. Fine. Yeah, of course I get paid $1,000 an hour. I'm worth it.
Right.
I do this. So, it's trying to figure out what are the things where you can go and say something that the jury's going to say, yeah, that makes sense to me.
And it's interesting because the focus groups we've been doing, we've been knee deep in these for the last couple of years. People don't get really upset that experts get paid. I mean, that's their job.
I think they look at it differently. They'll say, man, this person is a highly sought after person, must be for a reason. And of course they're getting paid $1,000. I've even had ones where they said, well, your expert was only a $400 an hour expert.
Exactly.
And, when going back to when I first started practicing, I had inherited this defense CME doctor on all of these cases that was used regularly. And, he'd graduated from Harvard and undergrad and gone to Yale Medical School. So all I ever told the jury was, of course we use him a lot. My job is to bring you the most qualified witness at no matter the cost. And look at his thing. Who else would you have me bring to you? And boom, and it was never an issue with that. So I don't think that money only matters in two things. One, if you can connect it to some other unbelievable testimony. Right. Why are they saying this? Because they don't really practice medicine. They make $2 million a year doing this. So that it's a connector on that. Why are they saying things that are so incredible? And again, if they're lying or not telling us all the truth about what they're doing there, about what they're making there, I think we just turn, why are you not telling us about something that isn't even the meat and potatoes of the case? If you can't tell us the truth about that, how can you tell us the truth about whether or not somebody has a permanent injury?
So that's interesting. So you're actually asking the expert, why aren't you telling us that? Why don't you keep track of the money? Why don't you keep track of the cases you testify in?
Yeah, what is it? And then they'll say, I don't have to. I said, well, okay, I get that nobody is sitting there grabbing your arm and forcing you in that manner. But that's a question that you get asked.
Right.
And jurors, you're asked this every week in courtrooms just like this across the state.
Right.
And instead of having this back and forth, if you wanted to, you could have a list. You could tell the jury, yeah, I did 400 CMEs this year. I got paid whatever the number
Sure.
is, and we'd move on.
Yeah, I
And
do the same
I'm just sitting
thing.
here trying to figure out why you can't be fully honest about something so basic as this.
Right.
And that's
What do you do when, because I kind of do the same thing when they leave that opinion out of their report and then all of a sudden bring it to trial.
right.
And I kind of do the same thing. You understand this system. This isn't your first rodeo. You've been to court before. You've written reports before. Lawyers are going to rely on that. And even though you knew everyone would rely on it, you didn't bother to take pen to paper and write that opinion in your report.
Yeah.
Yeah.
You could do it if you wanted to. I mean,
Yeah.
So, and then they'll say, I don't know how much money I'm making, when they know that they're making millions. Like, who among us wouldn't know that I've got a source of income that's 7 figures, right? And so it's that ridiculous nature of some of these things that I think
That
that
is
our
funny.
job is to reveal. And I mean, I had a case that's getting ready to go to trial, a stand-up forklift case, where the defense expert, part of our theme of the case is that these types of injuries have been happening for the last 30 years and they've done nothing to try and fix it. And so they have an expert who has been testifying for them for 15 years and has made $1 million plus as an expert witness. Fine. So I said to her, have they ever, while paying you that $1 million, said, can we take some of this money? Because I mean, you went to MIT, you've for an engineering degree, you're a medical doctor, you're smart as hell. Have they ever said, let's take some of those brains and experience that you have and ask you to work on fixing this problem instead of just defending it? And she's like, no, and then and that's not my role. And I said, well, are you telling me that if they offered you the money to come and try and fix this problem, that you wouldn't take it? She said, no, I wouldn't take the money. And I just think, so
you didn't care what the answer was. And that's
no,
something I think trial lawyers don't realize.
Yeah.
It was born into us, right? From the old books we had on cross-examination and everything we learned in law school. Don't ever, ever ask a question you don't know the answer to. And I personally don't subscribe to that.
I don't know how that is truly possible. And I don't know that it's truly desirable.
Right.
And again, I think, that was Irving Younger and his maxims of cross-examination. And I think that there are rules that are great for people when they're starting out and don't have experience, and it gives you comfort to be able to do that. But as you develop and you get more experience, then those rules have to be modified or cast aside. And I think that this is one of those rules. There are plenty of questions that you can ask that you don't care what the answer is. You just don't. Either way, you win. Now, the hard part is figuring out what are those questions.
Well, and you're right. And I've always said I've amended the old Irving Younger rule, which of course I listen to those tapes daily.
Sure.
I thought they were just, I still have them. They're some of the most entertaining tapes out there.
Right.
But I amended to don't ever ask a question that you don't know the answer to or don't care what the answer is.
Right. Right. Exactly. And so, you do that often. Again, it is some of the best stuff that we get with experts actually comes out of a conversation rather than an attack. They are trained to fight the attack.
Right.
They are much less trained for us when we are coming at them, not with frothing at the mouth type of thing, but in a more reasonable manner. It doesn't mean, of course, that there are certain witnesses that the armor comes on and the spears come out and the battle is joined, but you can never do that until the jury is ready for you to do that.
Right, which is kind of why I like that you only do that with experts, because by the time the defense expert comes on, unless they're bringing them in out of sequence, it's at the point of the time in the trial where you would have earned the right to do that.
Right.
Like if I'm cross-examining their expert and the jury hasn't given me the permission to do the real cross, I've probably lost that trial at that point already.
Yeah. Oh, there's no doubt about it. And you get the feeling, when the jury's ready for you to start doing what it is that you have to do. And so, it's all of those things that are the art of trial. We can read in books, and then there's the art that comes with it, and knowing when it is to ask a question. I had a case that I was trying, and it was a young man that had been driving his car, and there was a drag race, and they were in a wreck. And I'd also sued the mom because she was vicariously responsible. And so she sat in during the trial, and I put her on the stand because there were a few things that I had to prove through her. And then I just, sometimes you just feel that moment. So I said to her, you've sat in here for the last 5 days and watched the testimony that's happened. She said, yes. And I said, and your son for the last 4 years has been telling you a story of what happened. She said, yes. And I said, and now after sitting in here for these 5 days, you know that your son has not been telling the truth to you. And she paused and she said, sadly, yes.
Oh.
And, sometimes you have that feeling, but when you have that feeling, it's, like in was it A Few Angry Men, when they're telling, don't go for it unless you really feel it and all that. Sometimes you feel it and you got to go for it and do it.
But do you need a plan? But here's the one question I have, and then I want to shift to something else. But do you need a plan? So when you ask that question in your head, don't you have to have a plan if she says, no, he's been telling me the truth, of what you're going to do next?
Yeah, I think you have a plan about it, but you get to it at some point where one is you feel confident that you're going to get the answer that you want. And number two is the jury has seen what was there to be seen, and they've already made up their mind. They know that the dissonance between all of the other evidence and what he had said. And so there wasn't a real downside. If she says no to me, she says no, I still get to argue all the facts to the jury, and I'm going to expect, she's going to deny it anyway. So if I get this great answer, I get it. If I don't get it, I didn't feel like I would be
right. It doesn't matter.
Right.
Excellent. Again, we are here. This is The Jury Thinks What, and we are with Sean Domnick, excellent trial lawyer out of Palm Beach, Florida, one of the top trial lawyers in Florida and the country, and an old friend of mine. We've been through a lot of different things together over the years with AAJ. And that's something that if you're a listener and you're not a member of the American Association for Justice and you're a plaintiff lawyer, I'd have to have one question for you, and that's why not? Because if you have a question about a trial, Sean's available to you. If you have a question about a nursing home case, there's a bunch of us that are available to you. If you have a question about any case, there are lawyers that are available to you, and there are litigation packets you can purchase that probably will give you what you're supposed to do in discovery. So it's, for the small amount of money we pay, you get it back tenfold every month. So I would urge everyone to join.
You've got this nationwide law firm, really, that you're working with, and people face the same issues across the country. So it's not just in Florida that people have car wrecks where there's no discernible property damage, and you've got somebody with pre-existing conditions. But what I found is that people across the country have different ways of dealing with it, and some effective and some not. So you get to learn how it is that other folks are dealing with the issues that you're facing every day. And you might find out some ways to bring things into your practice that are going to allow you to effectively deal with those things in ways that you just hadn't thought of yet.
It's crazy because, I've been a member since '93. So I am now a stalwart, which is a little frightening. But if you have, I've been able to sit with Brian Chase just because I know him through AAJ and say, hey, I have this case about a car that doesn't appear to be working. There was something wrong with its Nissan car, and he gives me all the information I need. If I had a question about deposing a defense expert, I get on the horn with Dorothy Clay Sims, and that's like a 4-hour phone call right there. Right. But what you're getting is from the people who are top in their field are wanting to help you. Why? Because we're brethren. We're together. We're siblings. We're trial lawyers, and that's something we should all be a member of. But
it's the desire and the willingness to help, even if they don't know who you are,
right,
is incredible. And we recognize that the rising tide lifts all of our boats, and we are not in competition with each other. Your success is my success. My failure is your failure. And, that's the attitude.
One of my favorite parts of AAJ, and again, I'm one of the lucky ones. I've always been in more in leadership, as well, not always, but I became in leadership as well. But was sitting in that leaders forum room at a convention when all the guards are down and we're not being recorded, and listening to Papantonio or somebody else explain to me how they screwed something up,
Right.
and what they learned from that screw up. And there's not enough money you could spend to get that type of advice.
That's
right?
true. It's always better to learn from somebody else's mistake than make it yourself.
So again, this is Saul Gruber, the host of The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. We're here with Sean Domnick. Sean, I know you're involved in a lot of cases involving strokes. Why don't you tell us about that?
Absolutely. It's funny. We find in our careers, we kind of go through different phases and different types of cases. And I'd say for about the last 5 or 6 years, stroke cases have become a real significant part of my practice. And it coincided with, there was a real sea change in the world of medicine with regard to strokes. And most people that do what we do know about TPA and the clot busting drug, and that it has to be given within a couple of hours in order for it to be effective. And then in 2016 timeframe, they were doing studies on the mechanical removal of the blood clots. And they found that the new techniques were so effective that they actually stopped the studies because it was going to be unethical to continue to have a control group that they were not giving this to. And so now the window has been moved out to 7 to 8 hours from the onset of symptoms, and even in some cases out to 24 hours. So
wow,
that causation issue that used to be so difficult for us in these cases is now not the hurdle that it was. And it is, there are a couple of things about it that are frustrating that we see repetitively. One is the person comes into the emergency room, and so often the attitude of the healthcare providers there is, oh, that person must be a druggie or they're on some sort of drugs. And they kind of throw them in a corner to sleep it off when they're really having a stroke. And so we see that happen a tremendous amount of the time. The other thing that happens is there are different levels of stroke centers. And you'll hear about a primary stroke center or a comprehensive stroke center. The primary stroke center can only do the TPA. The comprehensive stroke center can do the TPA plus the thrombectomy, the mechanical removal of it. So, but regular people don't know the difference.
Right.
So you may be, oh, I think I'm having a stroke or something, and you're taken to one of these hospitals that can only do the TPA, and then they have to do what's called drip and ship. They start the TPA, and then they got to send you to a place that can actually do the procedure that you need to have. And an hour and a half lost when you're talking about brain material, that's a long time. So I don't think that they're being honest with people.
And not only that, based on what you're saying, I think there's a lot of lawyers out there that I did not know anything that you're telling me right now.
Yeah.
So I would assume there's probably about 85% of us that are out there that may be looking at these cases that don't even realize that.
Absolutely. There's no doubt about it. It's something that unless you have done a lot of these cases, that it doesn't really reveal itself to you easily on it. And, so we just, and stroke victims are getting younger and younger. We've got a case in Tennessee where our guy was 19 years old when he had a stroke. And wow. Yeah. So
you say Tennessee, was there a local firm that brought your firm into that case?
Yeah, exactly. That happens a lot. Where I'm fortunate enough to be able to do cases all over, because stroke, the medicine doesn't change figuring out what state you're in, and right. All of the standard of care is essentially no different, except for in some rare circumstances. And most of the time, the experts are not local experts, right? They're the people we use regularly. There are some states like Tennessee that have that contiguous rule where you have the 7 states where the expert has to come from, which of course ends up meaning that some of the really top-notch experts in the world don't get to testify there. But that is what it is.
Have you done anything in Georgia with their rule with the 25% of the expert's time cannot be spent on anything legal?
Yes,
Has
yes.
that affected some of the experts as well?
Um, it has, but the truth of the matter is that most of the experts that I use are not professionals in the sense that they're not 80%. These are people that with active university-based practices
Right.
that are doing this stuff tangentially with it. So it's really not an issue that I come with. These cases are hard, and the other side has unlimited access to whomever it is that they want, and we need to,
Right.
in this universe, we have to match quality with quality.
So let's break that down a little bit for me, because hopefully there's a lot of people listening who know nothing about this. Sometimes we'll get a case in, or my clients will get a case in, and it has nothing to do with a stroke. And maybe it's a fall case, or it's a perceived fall case, right?
Right.
Or it's the case where, yeah, my son had some problems, went in, then he died 8 hours later because they said he had a stroke. What should lawyers be looking for to think of this as maybe a stroke case?
Well, it's funny you bring that up, because in a lot of our cases that are called in as nursing home cases, where it's a pressure sore in a nursing home, and then it'll be, yeah, they had a stroke and they ended up in the nursing home, and I'm like, ding, 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 what
Yeah.
happened? What happened here? And did they get good care with regard to that? So you have to be alert. And one is, how did they end up in whatever condition it is that they're in? When it comes to strokes, and it's becoming a little bit less relevant as some of this medicine technology moves forward, but it's still really relevant. The question is, what was the last known well time? When is the last time that somebody saw that we can identify that this person was doing fine, and then the clock starts ticking for effective treatment from that? And where that comes into play for us a lot is in what we call wake-up strokes, where somebody wakes up with deficits. And so it's hard for us to know at what point that happened. But that's becoming, the biggest issue for that was because of the risk of bleeding with TPA, because it's a thinner. And so there was an issue that was happening there. Now with advancements in CTA and MRI machines, where they're now having MRI machines that they can actually bring bedside and do very quickly, that are designed to look for clots and things like that. We can start telling, is somebody still in the early stages of a stroke based on what we're seeing on the CT scan or the MRI. So the last known well time is still very, very important. I see a day where the technology and advancements allow us to gather that without necessarily having direct testimony.
So I'm an attorney. I'm in Memphis, Tennessee. I know my last name's not Gilreath, but I'm in Memphis, Tennessee.
Where are we going for barbecue?
Yeah. And I have this case. I'm going to look, and it involves a stroke. I didn't even realize it involved a stroke. The first thing I want to say is, okay, what was the last known well time?
Correct. When was the last time? And it's not enough that, well, I saw them at 11 o'clock last night and they woke up at 6 o'clock this morning. It is, when can somebody say that this person was doing well? And we have to be able to really identify that time period.
Now, how important is it, if I'm looking at it in that way, to talk to someone like you to find out what else has to be done? Is that something that has to be done right away, or can that wait 3 months?
No, I get calls all the time from folks that are talking about that. And you want to get the memories of the people who were involved. You want to get them as quickly as possible. Fresh memories are the best memories. People move, and you want to know the truth about what your case is. Do I have a good case, or do I have a bad case? I don't want to spend a bunch of money only to come in and have the fact witnesses destroy my case. So the sooner you get on those things, the better. I also think that because of what our experience in it, we have relations and know who the best places are for therapy. And therapy matters, and the level and the quality and the experience of the therapy matters, because at the end of the day, what's our number one concern? It's not getting money in a lawsuit.
Right.
Our number one concern is getting our clients as healthy and well as they can possibly be. And if I can help them get the best care possible, and I turn to them and I say, well, now your lawsuit sucks because you're no longer paralyzed and you're able to drive and have a job and do all that. I'd much rather say that to somebody than say, hey, you got a great lawsuit because you're never going to walk again.
Yeah, they're much happier too.
Right, right. Absolutely, absolutely. So, so it is important to get experienced people involved as early as possible and start getting the things that we need to get in order to evaluate what it is that the next steps are going to be.
You know, it's funny. The first nursing home case I had was in 1995, and I didn't even know that there was a regulations at that point. Right, I'd been a lawyer for like 6 years. I said, "Oh, who knew that?" And I reached out to a lawyer who's an old-time AAJ member and a good friend of mine, Ruben Cristal. And I said to Ruben, "What is all this about?" And after about 10 minutes of talking to him, I realized I didn't understand a word he said, A, because of his accent, and B, because he was using all these words about nursing homes. So I brought him in and we handled the case 50-50. We did everything together. And I kind of learned how to do it, which later on in my career happened to me, people bringing me in. Is that something you do with lawyers? They'll bring you in and they kind of learn how these cases are handled?
Absolutely. I get that a lot, whether it's on these cases or some of my cervical cancer cases that I handle and all that, what are the obstacles to these cases? One is learning the medicine.
Right.
The second is the cost. There are not a lot of people that are able to carry a case where, we're talking about expensive experts. When you're getting a neurosurgeon, a neuroradiologist, or a neurologist, and they're charging you anywhere from $1,000 to $1,500 an hour just to pick up the phone, you've got to be able to finance that and not feel like, oh my God, everything that is riding for the future of my firm on this one case. And so we're brought in frequently and we help teach people. They come to the depositions when I'm taking a deposition. We include them in our strategies sessions when we're discussing what the case is. We introduce them to our experts so that they can develop a relationship with them. And so then hopefully that they can, if they desire, do it on their own. And if not, bring us back in on cases. But the lifeblood of what we do is working with other lawyers.
Right.
That's really it.
And I think, I know I talked to Brian Chase a lot about that a few weeks ago, and it really is. It's to get involved in a case like that. It's not a car wreck. It's not and I'm not demeaning car wrecks. It's not a slip and fall. It's just that there's so much to show liability. And one thing we know is if you're going to be taken seriously, A, you've had to try these cases, and B, you need to be able to finance these cases.
Absolutely. And you got to, and when in the medical malpractice world, where today I'm deposing, a stroke neurologist, and then tomorrow I'm doing a neonatologist, and whoever it might be 3 days later from now, a gynecological pathologist. And so having to be able to be adept at understanding the variety of medicine that you're dealing with and being able to be as conversant as you need to be. And every medical malpractice lawyer thinks they're a doctor. we all do that. But it is a lot of work to get to that point of being conversant in all of these things. And I spend hours and hours, and of course it's so different now. When we first started practicing, I was practicing in Miami, and I'd go to the University of Miami Medical School and sit in their medical library and read books. Now, of course, we've got it at our fingertips, so it's a little bit easier. But I was up last night at home until almost midnight doing research on a case that we're looking at. And so there's a lot of time that's put into it. And if you're not heavily involved in it yourself, it's kind of like when you're doing research, legal research, you can have somebody else do it for you. But the problem ultimately comes that in the legal research world, in the process of doing your research, you reject a lot of cases, and you know why you rejected them. And so if you're in an oral argument, a judge says to you, what about this? You remember why you rejected it. But if somebody else did it, you don't have at your fingertips the reason why you rejected that case that is now brought up to you. And so it's very much the same way here. If you haven't dive down into it yourself, then you're losing those gray areas that are there, and it makes it much harder. So it's a lot of work.
Yeah, it's funny you say that. I always hated going to oral argument where someone else wrote the brief for me, because I knew no matter what, I don't know it as well as the person who wrote the brief.
Absolutely. Absolutely. And it's not about the cases that are in there in your brief. You read those and you get those, but it's all the cases that were looked at that are the gray areas that were rejected for one reason or another that you never read, that makes it much harder to distinguish why that case doesn't apply.
I used to say to the medical malpractice part of our firm that I was the lucky one because I ran the nursing home part of the firm, and I just had one set of laws to deal with, right? I had, pressure ulcers, nutrition, falls, and they went from orthopedic to OB to neurology.
Yeah.
And if they were going to know it as well as I didn't know when they slept.
Yeah, it's hard, but it's funny. I was in before the pandemic set in, I was in New York taking the deposition of a defense neurologist, and we kind of as an expert, and beforehand we were getting coffee together, and we kind of started talking about stuff, and just we're getting along fine, and the deposition was fine and all that. We took a break, and we're both getting coffee again, and I was saying, you spent your entire life working on stroke, dedicated to people. I mean, your CV is so thick and just done all this wonderful work. I said, it's got to be a little disconcerting that we're sitting here in this deposition, and here I am. I went to a public school with a degree in finance, and I'm asking you questions about your life's work. And he laughed a little bit, and I said, the thing that's really got to get you is that you know that I'm right. And I normally wouldn't do that, but we were getting along.
That's too funny.
Joking with them about it, but it is a ton of work.
So what we learned from Sean is don't be bashful and be ready to work very long hours if you're going to try cases. Sean
100%.
Domnick Cunningham in Whalen, Fred and Jean Marie are your partners. I know them well. A great firm in Palm Beach County. If anybody wanted to get in touch with you or anyone at your firm, how should they do that?
Well, the phone number is 561-625-6260. You can see there, dcwlaw.com is our website. And my email address is sean@dcwlaw.com.
And Sean also wants to tell everybody, if you're listening to this and not a member of AAJ, email him or me right away and we'll get you signed up, no problem.
Absolutely. Join AAJ. I promise you that you will be a better lawyer. Your clients will be better represented if you join AAJ and take advantage of it. And as I tell everybody, join and then don't hesitate to reach out to me, and I will do everything that I possibly can to make sure that your needs and desires are met.
And I know that to be true because Sean's actually done that for me as well. So Sean, thanks so much for coming on with us. And I really appreciate it. And I will see you soon.
Thanks, Saul. Have a great day.
Thanks. And again, this is Saul Gruber from Gruber Trial Consulting, your host from The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. And we heard some great tips from Sean Domnick from looking at the case in an analytical way, how to reduce the time you're actually taking testimony, and how to really go after experts. I thought Sean really hit the nail on the head when he discussed learning your client's story by spending time with them, going out to their home. And he really gave us some insight on some stroke cases. So some really good stuff by Sean. And again, this is Saul Gruber, your host of The Jury Thinks What.
That concludes another episode of The Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.